Well, hello there and welcome back to the Employment Law Show. We're back again for another show. John Scholes here, right there, Lior Samfiru. Reach out, EmploymentLawyer.ca. I always tend to give you the contact information off the top to reach out to Lior and his team on your own time. The number, 1-855-821-5900, help@EmploymentLawyer.ca, and the only website you'll ever need is pocketemploymentlawyer.ca. It covers most of what we talk about here weekly on the show, and you'll have free access and anonymous access to the severance pay calculator all rolled into Pocket Employment. You'll see how it works a little later on the show. Lior will take it for a spin for sure. And a main topic, we always have one this week. It's going to be return to office mandates, questions Lior gets. That's in the future very shortly, and we'll get to some phone calls from our long-running radio shows across the country, so we're looking forward to that. If you've called the show before in the recent past, it'll maybe your voice on air very shortly, so stick around for that. But, Lior, I digress. Always start off with the week that was. What is happening with you, pal?
John, great to be here to talk about employment law, to hopefully help solve some of those workplace issues that I know our good viewers are dealing with. I know because I spend all of my time working with people, helping people understand their rights, answering questions, and of course making sure that those rights are enforced. You have rights. If you're a regular viewer of the show, hopefully by now you're starting to understand that the law is there to protect you. You have rights. If you lost your job, you have rights. If your boss is telling you you must resign, guess what? You have rights. If you're put on a temporary layoff, yeah, you have rights. Of course, if you're being mistreated or your job is changing, you absolutely have rights. That's the theme of the show, the rights that you have in the workplace. And we want to educate you so that you're not worried about it. You're not losing sleep, and don't walk away from those rights that you have. Of course, this is a 30-minute show. We can only talk about so many things, but that doesn't mean that you can't ask other questions and get help beyond the show. You can reach me in the office, my team across Canada, frankly, and we'll give you that contact information many times throughout the show, so stay tuned for that. But I always like to start off with what I call the case of the day, a situation that came across my desk very, very recently. So I spoke with a gentleman who has been a truck driver with the same company for about 7 or 8 years. He's always done the same route. He was happy with that route. It paid him very well. He structured his life around being able to do that route, and things were fine. Well, very recently, his employer told him, we're going to take that route away. We want someone else to do that route. We don't really have a regular route for you, so you're going to be on call. We'll be calling you when we need you to drive. And that's the new relationship that we have with you. The other thing this person told me is that for the 7 years he's been working as a driver, as a truck driver, he's been an independent contractor. His question ultimately for me was, what are my rights? Well, let's start with the latter point, and that is he's not an independent contractor. And I see this tons of time with truck drivers, that they're misclassified as contractors when they truly and really are employees. If you work for one company, guess what? You are their employee. You're not an independent contractor. Now, what does this mean? It means that this change that his employer has done, they took away the route, they didn't give him a regular route, now he's on call. That is a significant change in terms of employment. It's what we call a constructive dismissal. By changing the terms of employment, they don't have a right to do that. He can now consider his employment as being terminated. And yes, because he is an employee, he's owed severance. He's been there about 7 years. He's probably going to be owed 8 or 9 months severance. He's a bit older. So that's what's at stake for him. So there's very important lessons there for many people, not just truck drivers. You're likely misclassified if you have a regular job and your employer is calling you a contractor. You're likely not that. You're likely an employee in the eyes of the law. And of course, the big lesson, as always, we've talked about this on the show before, your employer cannot just make significant changes to terms of employment. If they do, you may have the ability and the right to consider that a constructive dismissal and force your employer to pay your full severance. Of course, if that's your situation, before you do anything, call me.
What are the long-term repercussions, Lior, if he did say yes and says, okay, I'll go along with it, doesn't sound too bad, ends up being terrible, but now he's kind of accepted it, right?
Well, that's the problem. If his employer is doing something, they took away his shift, they took away his route, and they don't give him something good. If he doesn't pursue a constructive dismissal, he's going to be considered to have accepted it. And then they can make other changes and stop giving him shifts at all. And he may not be able to do much about that. So when you open the door to something that your employer is not allowed to do, you've given them the right to do it again and again, and you really, really don't want to do that.
Can he dip a toe in? Maybe, take it out for a spin, as we say in the show, before he commits full on to it?
The dipping the toe is a technical term, so just so
legal
we're
term.
clear, very legal term. No, but he can to an extent, and what he could do is say to his employer, listen, employer, I'm very concerned about this, but here's what I'm going to do. Let's do this for the next few weeks, see how things pan out. So let's do this for, say, 3 weeks. And if things are okay, I'll let you know. If they're not okay, we're going to have a further discussion. So that may be something that he can do. If he doesn't say anything, if he just continues working, hoping for the best, yeah, he's going to be considered to have accepted it, and that's just a recipe for disaster later on.
Again, EmploymentLawyer.ca. Anytime you want to reach out to Lior, you can do so on that website. All kinds of things to be learned, including contact information and finding a radio station in a market near you where you can listen to one and tune into and call into as well. We love getting your phone calls on the air. We'll get to one from one of our radio shows now. Have a listen, and we'll pull it apart, Lior, like we always do.
I got terminated from my job, and the letter just said without cause. I was only there 14 months, but I was hired as a parks manager, sold my personal vehicle. We had an agreement about all that. So unfortunately, I lost my vehicle, I lost my phone. He's giving me 2 weeks severance. I didn't know if that's fair for only being 14 months.
Parks manager, been there for 14 months. How old are you?
40.
What do you think? How's the math work out for that one?
So I think if we were to just take a walk down the street and ask people, listen, this guy's worked there for about a year, 14 months or so. He was offered 2 weeks pay. What do you think? I think a lot of people exactly are going to say, yeah, that's okay. 2 weeks per year, maybe that's fine. Well, let's talk about that. I'm going to spoil it for you. It's not fine. Remember what I've said on the show before. Short service employees, this guy's only been there for 14 months, are treated disproportionately better than long service employees. So yes, even after 14 months, he's going to have significant severance entitlements that are measured in months, not weeks. So no, 2 weeks is not even close. So I'm going to show you how you can find out for yourself what you'd be owed. And let's take this information and let's plug it right now into our severance calculator tool. We're going to go to PocketEmploymentLawyer.ca. We're going to click on the severance calculator and plug in this information. Let's see what that gives us. So we know that this person has been there for 14 months. He's 40 years old in a managerial role. His employer says 2 weeks severance, so that's all you get. You see on the screen he's owed right around 4 months of severance, not weeks, but months. That's a huge, huge difference. So no, he's been wrongfully dismissed, John, and anyone at home can do this as well, free and anonymous. Check out PocketEmploymentLawyer.ca.
You say disproportionately better. Why is that? Why is that the general rule with short service employees?
Well, you have to keep in mind the purpose of severance. The purpose of severance is not to punish your employer for letting you go. The purpose of severance is to help you while you don't have other income. So if just because you work for a company for a short period of time doesn't mean you're going to find a job within a week or two. It's still going to take you a long time potentially to find another job. So that's why someone that's even been there for a few months is going to likely be owed a few months of severance. So that's why it's so important you call me. It's so important to use the severance calculator. Every single day I speak with people that after 6 months, 12 months, 15 months are offered almost nothing. And in fact, they're owed probably 5-6 times that.
Again, that severance calculator, just to tell you again, PocketEmploymentLawyer.ca is where you'll find it. Now, Lior can do it by memory, of course. He's done it a billion times, but for you and I, it's easy just to use that free app rolled into the website, PocketEmploymentLawyer.ca. Okay, phone call number 2. We always do 3 in the show. Second one is coming right now. Listen up.
So I was talking to a friend the other night, and he was distraught, and I asked him what's wrong. He said they've changed my shift. He worked at a factory for 35 years, straight days. Now they've changed things, and they've put him on shift work. He's worried he'll get fired, and he's on the shift now. How long does he still have to dispute that before they've deemed it, well, you've been on this shift now for a month or 2 months. You can't go back on that now.
Fantastic question, and it's a very important question to ask. So let's break this down. Let's start with the idea, of course, that his employer does not have the right to make that change, to go from regular hours to shift work or to change your shift in such a significant way. That's a constructive dismissal. That's, as we were saying before, the type of change that your employer is not allowed to make. Now, that doesn't mean you can physically stop your employer from making that change. What that means is you may have the choice to say, I'm not okay with this, I'm not accepting this, instead I'm going to leave, consider this a constructive dismissal. Now, employer, you have to pay me my severance. The real question, of course, is, Well, if he's been doing this for a while, they changed his hours, his shifts, he's been doing this for a while, when is it too late? Generally speaking, that's going to be a few weeks. Now, every case is different. Sometimes it could be a bit more or a bit less. But usually, if we're going beyond 3-4 weeks, we may be considered to have accepted what the employer did. So if you're faced with a significant change to terms of employment, a reduction in pay, a reduction in hours, a demotion, you can't sit on that. You can't sit on your rights. We have to deal with this right away, because if you don't, you may be considered to have accepted it, and then you're stuck in that situation. So if you're being faced with that change, call me right away.
We have a third phone call coming up, and then we'll get to our main topic as well, but we always take a short break in between all that, which we're going to do right now. So get you to write this number down as we get into a break and come back just a couple minutes. It's 1-855-821-5900. Help at EmploymentLawyer.ca. Lots more. The Employment Law Show is on the way. Don't go anywhere. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Employment Law Show. Look, we're standing. We are going to continue on here. We always do 3 phone calls on the show. We heard 2. They were great. Thank you so much ahead of time. EmploymentLawyer.ca. You want to find a radio station across this wonderful province and country, for that matter, that carries our show, and maybe your phone call will appear on a future show. So let's get to it. Lior, phone call number 3. Listen up. It's coming right now.
I'm actually calling for my daughter. She's been working for a large international company for about 8 years. She has just been recently diagnosed with an autoimmune disease and was put on accommodation. She's been working. There's no problem. However, she just got an email saying that they're not going to proceed with the accommodations anymore and that she should go on a leave of absence.
That actually doesn't sound that uncommon.
It's not uncommon, but the fact that it's not uncommon doesn't mean it's not illegal. So let me spoil it by saying, yes, it is illegal. I'm going to break it down. So an employer has a duty to accommodate. It's one of the most important obligations that an employer has. It's under our human rights legislation, which means if you have a physical limitation and you require support from your employer, that support must be given by the employer if they can do it. Modified hours, modified duties, maybe no lifting restrictions, maybe working from home, if that's what your doctor says. Now, we know that this employer is able to accommodate. They've been doing it. So this employer has been accommodating. It's been going fine. Now they've decided, you know what, we just don't want to. We're going to put a time limit on that. Well, guess what? There's no time limit on accommodation. It can be indefinite. And because we know the employer is able to accommodate since they've been doing it, now they can't just refuse. They can't decide unilaterally to stop accommodating. It becomes a human rights violation. So no, this employer is doing it wrong. They must continue to accommodate and abide by this employee's restrictions as outlined by the doctor. So what I would tell her is, call me. Usually once they hear from me, they backtrack. They'll accommodate so fast your head will spin. So do the right thing, do the smart thing. Understand that you should and must be accommodated. Call me if that happens.
Again, after our main topic, let me give you the phone number out first to reach Lior on that matter or anything else that concerns you. 1-855-821-5900. Okay, return to office mandates. This is a huge topic. It has been growing ever since really the end of the pandemic. The first question you get, Lior, is this: can my employer force me back to the office if I've been working remotely for a long time, or even was hired as a remote employee from the start? What do you think?
So certainly over the last year or so, it's been one of the most common situations that I've been seeing in my practice. Employees calling me and saying, well, I've been working from home, let's say since the pandemic, either full-time or certain days from home. Now my employer wants to change this. They say, I can't work from home, or I have to work from home less and come into the office more. I've built my life around the ability to work from home. That's what I have now. I have childcare obligations, other family obligations. I don't want to go back. So do I have to? So let's answer that. No, at this point, if you've been working in a certain way since the pandemic, it's too late for the employer to force you to go back to the way things were before the pandemic. They can't change the terms of employment and say, now you have to come in 5 days, 4 days, 3 days. Now, the fact that they can't do that, again, doesn't mean that you can prevent them from firing, from letting you go if you refuse. So here's what happens. If you tell your employer, no, employer, I'm not doing that, either they'll back off and leave you be, or they may say, okay, then we're going to let you go. But if they do that, if they let you go, they're going to have to pay you your full severance. It's not a resignation. It's not grounds for a termination for cause. It's a termination with severance, keeping in mind, of course, that an employer can let you go for most reasons as long as severance is paid. So yes, they can say your refusal to come in means we're going to let you go, but full severance must be paid.
So the backdrop of the pandemic, that time has expired. They can't use that. Oh, it was only for the pandemic. You got to come back now. That's gone.
Well, that limitation, that restriction probably went away a couple of years ago, at least now, when there was, certainly early in the pandemic, there was a very good reason to have employees work remotely. But certainly over the last 2 years plus, that reason has gone away. So if the employers continue to have employees working from home, it's now become a term of employment. And the employer can now just not unilaterally change it.
We're talking about return to office mandates. Question you get number 2 is this, Lior. What are my rights if I can't return to the office due to medical issues or caregiving responsibilities? There you go.
So I said earlier that generally speaking, if your employer wants you to come back into the office and you say no, you can be let go with full severance. Well, not in this situation. If there's a medical reason that prevents you from coming into work, or a family situation, a childcare obligation that prevents you from being able to come into work, you cannot be let go because of that. That would be discriminatory. Disabilities and serious medical conditions are protected under human rights legislation. What we call family status is also protected under human rights legislation. So if you have a legitimate medical condition that prevents you, or the only way you can care for your child is by being home and working remotely, your employer must allow that to happen, or they'd be in violation of human rights laws. So what I would do in that situation, John, is I would write to my employer, again, always in writing, right? Say, employer, here's why I cannot come in. I have this medical condition. Here's my doctor's note saying that I cannot physically come into the office. Or I have these childcare obligations. Here's why I can't make other arrangements, or here's why my family can't help me. The only way I can meet those obligations is by working from home. At that point, the employer must accommodate, must allow you to work from home. If your employer doesn't, as I said before, call me. And again, once they hear from me, things will change very, very quickly.
We're covering off return to work mandates. Number 3 question, Lior, is my employer allowed to change my job when I finally return to the office, if I do?
So, okay, you've decided you're going to go back into the office. You're okay with that. Maybe you're looking forward to seeing your old colleagues, so you're going back into the office. Well, the same rules apply. Your employer is not allowed to make significant changes to terms of employment. So just because you're going to come back and work from the office doesn't mean you can be given a different job than what you've been doing. It can't be a demotion or different shifts or a position that clearly is vastly different from what you were doing before. If that happens, again, this idea, this concept of constructive dismissal still applies. You may be able to treat that as a termination. I want you also, of course, to remember that not every change is a constructive dismissal. So before you walk into your employer's office and say, that's it, I'm out of here because of constructive dismissal, I want you to call me. Don't speak to your employer before you speak to me, but that's certainly going to be an option we can discuss.
And that's kind of where we're leading with the final one, right? Should I contact EmploymentLawyer.ca before signing over to that return to office mandate, right?
So remember that everything I've said to you now applies in general terms. There's always going to be specifics that may change things one way or another in favor of the employee, in favor of the employer. So the best advice I'm going to be able to give all our viewers, if your employer is changing your terms of employment, if your employer is telling you you must come into the office, you must change your hours or days of work or how you work, call me before you do anything. Before you tell your employer yes or no, before you tell your employer I'm quitting, before you do any of that, let's have that discussion. Devil's in the details. And oftentimes, I can even help you avoid that situation altogether. So let's talk first before you do anything else.
Covered off the topic for this week. We'll take a small break, get back into more. We're going to go to a website called terminationquestions.com. For that question, you can use that anonymously anytime. That is on the other side as we continue more of the Employment Law Show. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the Employment Lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the Employment Lawyer first at EmploymentLawyer.ca. All right, welcome back. Short break there. Employment Law Show continues. John Scholes and Lior Samfiru. Reach out to Lior anytime. We'll give you the phone number again, 1-855-821-5900, help@employmentlawyer.ca. And I did mention terminationquestions.com. That's a great website, completely free and anonymous. You can ask your questions there, and somebody in Lior's team will answer them, and they may, like our phone calls, appear on a future show. For this week, here we go. Lior says, I was terminated today due to frustration of contract. I've been on a back-to-work plan, working 20 hours a week, which my insurance company approved for the next 6 months. However, my employer claims I am incapable of doing my job. Am I owed anything? I'm almost 60 and have been a technician for 11 years.
So before we answer this specific question, what is frustration of contract in this context, in the context of a disability? Well, let's clarify that. Frustration of contract is a situation where you're not going to be able to work again, where you're not able to be accommodated, there's no accommodation, and it's clear because of your medical condition that that's it. Unfortunately, you've gone to the point where you're not going to be able to work again. If that is true, if you've been off for a while, you're not going to be able to come back to work again, the employer may be able to terminate what we call frustration of contract, and any payment obligations that they have towards you will be minimal, if any at all. So it's not every situation where you have a medical condition that's frustration of contract. In this particular situation, the question is, number one, can the employer accommodate the employee? If the employer is able to accommodate, they must accommodate. They don't get to say, too bad, we don't want to. This is not the job we hired you for. That's why we have human rights laws saying you have to accommodate. The second thing, even if the employee cannot be accommodated, well, are those restrictions fatal? Are they forever? Are they indefinite? If these restrictions are temporary and the employee is going to be able to go back to regular duties at some point, it's not a frustration of contract. So it's very likely in this scenario that the employer is able to accommodate. So if they let the employee go, that employee is owed human rights damages and, of course, owed severance as well. So one more thing we need to do, and that is to figure out how much severance this person is owed. Easy to do. We're going to go back once more to pocketemploymentlawyer.ca. We're going to plug in the information in our severance calculator, which you can find on our website, and let's see what that gives us. So we know that this person is, a bit older there, in a technical role. Company says, we're not going to pay you anything. It's a frustration of contract. Well, we see right there after those 11 years, this person can easily be owed 12 to 14 months severance. Significant entitlements. And by the way, that's in addition to any human rights damages. So, of course, if your employer is letting you go because of your disability, we need to talk right away.
Frustration of contract seems weird considering he's already back at work 20 hours a week. 20 hours a week.
So clearly this is simply an employer saying, we just don't want to accommodate, so we're going to say frustration because you can't work 40 hours a week. Well, that's what accommodation is for.
That's right.
You have to accommodate those modified hours. You don't get a say there.
All right, next one. Live stream at Facebook. Lior does that, and including to practicing law and answering all of your questions. He can be found on YouTube and LinkedIn. You want to join that program anytime and chime in at stlawyers.ca, at stlawyers.ca. And the question from the live stream this week, Lior, here we go, says, I have a new manager. We do not get along. I've brought this up with HR, but nothing has been done about it, and the harassment continues. Recently, I was given a PIP to sign, a performance improvement plan, which is completely false. I was told if I don't sign, I'll be terminated immediately. What can I do here?
So first of all, if you're being harassed, mistreated, bullied in the workplace, yes, you have to talk to your employer, the right person within the employer. But I want you to go beyond talking to them. I want you to send an email. I want you to send an email in writing to that employer saying, hey, employer, I've been mistreated, I've been bullied, I've been harassed. Here's all the information. I need you to do something about it, because you don't want your employer to deny it or deny knowing about it. If they don't deal with it, you call me and I'll make them deal with it or get you out of there. Now, with respect to the performance improvement plan, if you say it's not legitimate, it's not fair, it's made up or exaggerated, well, don't just tell me. Tell your employer that. Write an email back to your employer saying, here's why I don't agree. Yes, I've acknowledged that I've received a copy of this. I have it. But I don't agree, and here's why. Okay? You didn't account for this, or this is not true, or this is not accurate. Be professional, but write that. If they let you go at that point, it's going to be a without cause termination. You're owed severance. You don't want to just be silent in the face of an unfair performance improvement plan. That can be used against you later on to potentially terminate you for cause. But of course, best advice. That's a complicated situation. It's an uncomfortable one. Call me.
So if we drill down a bit, Lior says, I was told if I don't sign, I'll be terminated immediately. Do you think they'll be terminated for not signing or not following the PIP? Does it make a difference?
It really doesn't make a difference, because either way, that would be a without cause termination, meaning they have to get severance. Remember, your employer can let you go even if you've done nothing wrong. Now, it's not a nice thing to do, of course, but legally they can, so long as severance is paid. So it's better off, frankly, to lose your job not having signed that and get severance than to sign it and that be used against you later to potentially terminate your employment for cause. But which is why I said, devil's in the details. Let's talk before you do anything.
Is that generally a precursor to being let go? Performance improvement plan? They're starting to build up a case, as you like to say?
That's the right term, building up a case. Your employer's only doing that not because they're bored. They're doing that because they want to have that there in case they decide to terminate you for cause as ammunition. So don't let them get away with it if you don't agree with it.
Lior is under the gun for the next couple of minutes as we get into employment law rapid fire. Let's get that happening. Okay, here we go. Question number one for rapid fire this week, Lior. Get on your shoes and start running. Can an employee record conversations in the workplace? I love this question.
An employee can only record conversations that employee is a part of. So you can record yourself talking to someone else talking to you. You cannot leave a recorder to record other people's conversations that you are not part of. That actually could be a criminal offense, so be smart about it.
So you and one person or you and 12 people, you got to be there.
You and 12 people is fine. The 12 people without you, not legal.
Question number two, can an employer force an employee to resign?
No. By definition, John, a resignation is something that the individual does on their own, unilaterally. So if someone is forcing you to resign, it's no longer a resignation. It becomes a termination. Don't do that. And if you are forced to do that, put that in writing that that's what you're doing and call me, because you're still going to be owed severance.
Rapid fire question number three for week, Lior, and this one's like the elephant in the room. Are temporary layoffs legitimate?
For most people, John, non-union individuals, they're not legitimate. You have the right in most cases to consider that temporary layoff as a termination. You don't have to sit at home for months waiting and hoping you'll be called back to work. You can do that, but you can also treat that as a termination now, not waiting later, and get your full severance.
Question number four for the newbies to the show. You might know the answer already, Lior. Well, they might anyway. Do you need to accept a severance offer by your employer's deadline? It's right at the bottom.
Every severance offer has a deadline. You have to sign this by Friday, Thursday, whatever it is, at 5 o'clock. It's a pressure tactic. Your legal rights do not expire on that deadline. Once you sign off on that, you can't go back. Don't let that happen to you. 90% chance that offer is not good, so don't worry about that deadline.
Okay, you're 4 for 4. Let's wrap it up with number 5, Lior. Rapid fire question is this. Can an employee be let go due to their conduct online?
You can. You can be let go with severance for pretty much anything. You can also be let go for cause for your conduct online if what you did impacts your employer in a negative way. So always be smart about what you put out online.
And that'll just about do it for this week. Rapid fire, favorite part of the show. He's got a little bit of a sweat going there, but he'll be okay. Moving forward, how do you reach Lior? 1-855-821-5900. Help at EmploymentLawyer.ca or pocketemploymentlawyer.ca. We'll see you next week.